this is their exhibit that she was convicted of concealing from their account. And that's the same. It's just that one has more filled in because after they turned it over to the auditor, Susan continued to fill it in. In Defendant's Exhibit 44, from May 9th of 2019, now this is after the Easter Rodriguez car. After Rodriguez car, to the Bexar County auditors, and I received this in a subpoena, this is their exhibit that she was convicted of concealing. It's the same. And so what they have is they have that Michelle or her office, because she really wasn't doing it. You'll notice Susan Tristan's name on it. But what Michelle was, when the auditor said we needed cash logs, they got cash logs. Now, this is interesting. In 40, this is a cash log. If you use this Christmas tree here. This is a cash log that's not even included in any of the state's evidence, or the cash logs that was found in Susan Tristan's possession. And I pointed out to say, if you took the state, because from the very beginning they had this idea that whatever Michelle does is wrong and we're going to find how it's wrong. So you could look at that and say, well, that's the evidence. Michelle took it, shredded a cash log. But it's not. When Susan Tristan testified, she testified that all of the cash logs that were found were all the ones that she had, which is not true, because that exhibit that she holds in her hand is an additional cash log. Now, at the time that that's going on, this is back in 2018, there is no, I guess, motive to conceal. Easter Park has, or Rodriguez Park hasn't happened. And I pointed out to say, perhaps, there wasn't this intent, this nefarious intent to conceal, this nefarious intent to hide some sort of crime that the state still has not put their finger on. And I'll point out, even in the punishment, Mr. Salinas is asking her sister-in-law about whether or not she's used cash. Five months. They're still, even at this late date, trying to find some sort of evidence that they're reaching for something that they can show is a reason why she would do this. Because they haven't. They're all bankrupt. They haven't present any reason that she has ever financially benefited. Now, going back to what they're going to argue to you, which is she's a public servant. But here's the thing. A public servant isn't above the law for sure. Michelle is evidence of that. She is living, sitting proof of that. But they are not below the law either. And what that means is, just because they are there, the court still needs to take it. It's not an axiom in our system that if you are a public servant, you go to prison if you're convicted of wrongdoing. The wrongdoing has to match, and the punishment has to match what she's convicted of. And it goes back to this fact that she has been convicted of concealing documents that were not concealed. They are arguing that they were not turned over to the DA's office. They were turned over to the auditor's office. And in fact, if the DA's wanted it, they could have gone to their own agency, their own auditor, and got the cash logs that they ended up presenting in trial as evidence of her crime. Those were provided by her office. But she's been convicted of concealing documents that were not concealed. They were not in her office. They were not in some secret place. They were not anywhere else but in Susan Tristan's folder where they always were. There is no dispute that she had every opportunity to take those out, to do whatever she wanted to do with those. If she felt like she needed to cover up her crime, instead she had 7 copies made of them, of these terrible, terrible documents that she was breaking. And as far as the writing, now their interpretation is I mean, they said that it was false. I've never heard any evidence, and I still have not heard evidence about one false thing that's on this document. But I've heard that, oh, this document had something different than this one. You can assume, as the state wants you to, that she was trying to do this to somehow hide some crime that she had committed. But if you do that, they have to explain to you what's false. They have to explain to you something that shows a motive. Because if they don't, you could also believe that she was doing exactly what it looked like, which is, Susan, your records are not good. I'm trying to figure it out. And the reason why that makes more sense is because stayed in Susan's folder where the other stuff did. It was never sent to an investigator to try to mess up an investigation. And when you look at that, and Mr. Lillen pointed that out, I mean, this is like a draft. It's got crossed out stuff. I mean, this wasn't intended ever to be anything other than personal notes about this garbage that Susan was doing. Now, she is the constable. She's responsible. She's responsible for making sure Susan does the right thing. Nobody is arguing any differently. But what we're saying is, we're talking about prison. We're talking about going to prison. That's what the state, I'm assuming, is going to ask. Or to be incarcerated somehow as a condition of probation, and neither of those are appropriate, because when it comes down to where we look at what she was convicted of, that even taken as if all of that were true, and the verdict was sound, which I do not believe, but I will be taking an argument that it was true, then that is probably the lowest possible way that you could possibly commit that offense. Because even one step up would be taking the Susan's out of Susan's law. I mean, one step up would be typing this thing up and trying to present it to an investigator, or doing something other than a bunch of squiggles and wiggles, and nothing was proved false. Susan Tristan was on the stand. She didn't say, "Oh, that's a false statement." All she said was she was trying to write it from memory. Right? Now, one of the things I didn't point out is that in 31-2-9, I should have. It's one of those things that I've had a lot of time to reflect on the trial that I regret. Because Susan was not telling the jury or the court the truth about that. Because if you look at 31-2-9, and then I'm looking on what we call the Christmas tree, it's 17-3, these are written out word for word. When it says a Castillo, it's a Castillo. When it says Castillo, it says Castillo. There's no way she's reproducing this from memory. She's sitting with Susan trying to figure out what this means, and if Susan has adequately and accurately reported those things. Now, I'm not saying that there aren't maybe differences, perhaps, because I don't know the conversation that Susan had at the time about, well, okay, I had this, but we also did this. I mean, you can see in some of these documents that at one point there's a receipt number written in after they give it to the auditor. So what it means is when they gave it to the auditor, Susan didn't have the receipt number. She came back and wrote in the receipt number. It's in her handwriting. So you can see some of the differences between. But this is word for word. This is exactly, it's written exactly. Where it says void, it says void. Where it says this, it says this. And so Michelle wasn't sitting there trying to write it from memory. She was sitting with Susan, trying to figure out what was going on. Because they had received a subpoena. All that is true. And she's trying to figure out, what are they asking for? What are we doing? What have you done with these records and these documents? That takes us to the punch. The state at the beginning told me that they were going to prove that Michelle committed aggravated perjury, and they did. You know, I was trying to think of like what an example of it was, and it's kind of like if Moreno said, "I think SUVs are the best type of vehicle," and then Mark Garcia says, "That's a lie. SUVs aren't the best type of vehicle. We committed perjury." And then the DA's office says, "That's a lie. It is not perjury to say that SUVs are the best type of vehicle. You've committed perjury." So ultimately, it's ridiculous. The affidavit that they have in evidence that Mark Garcia wrote, the statements that he made, are ridiculous. They're just opinions. It never should have been signed. A warrant like that never should have been signed by a judge. But there's a difference between perjury and being ridiculous. There's a difference between perjury and...
Well, I'm going to interrupt your closing, and I want you to walk me through your client's actions after this ridiculous warrant was signed. I want you to walk me through your client's actions by text message to distance herself from this wrongful arrest?
Well, here's where I'm going to get to, is that first of all, the once Mark Garcia does, now Mark Garcia is her captain.
Well, hang on, Mark Garcia's testimony was excluded by the court and not considered. But I can consider your client's actions after that.
I understand. And so,
Walk me through what the evidence is for actions were.
right, so you look at Mark Garcia. So first of all, you have to understand what you have heard, the testimony that you have heard about who Mark Garcia was in this case. Right? He was her captain. He was somebody with authority. He was somebody who did his investigation, and Mr. James told you from the stand. I think quite credibly told you that Mark Garcia was fixated on the investigation, did the investigation, was told like, hey, maybe don't do this, maybe do this, but said, I'm going to do whatever, I got this, I'm going to do it. Now, once that happened, and once he made the arrest, I'm not saying, and none of it, I'm not saying that Michelle herself wasn't believed that, that this is a false thing. Mark Garcia told her, and he obviously had confidence in his investigation, and she had confidence in her captain. And so,
Misplaced.
Absolutely misplaced.
That's your argument, that she had misplaced confidence in Mark Garcia.
Well, absolutely, but here's how you know just from the evidence that you have from the text message. So what those text messages are showing, and I was pointing this out, I was talking to Jackson about this yesterday. What those text messages show is that once Mark Garcia made his decision that he believed that he was right, she has sent Mr. James in, and he has said, look, I got this and everything else. But once that happened, what is she going to do? She is going to back her captain. She believed in him. She believed that what he did was right. But how do you know that? Because she didn't slink off like, oh my gosh, the DA's dismissed it and everything else. Those text messages show she's going back to the DA's saying, look, this is the evidence of perjury. This is the evidence of it.
You just call that evidence ridiculous.
It is ridiculous. I know it's ridiculous, and you know it, and they know it. She did. Nobody is saying that she's a loose fellow. Nobody is saying that she is the paragon of law enforcement. I'm gonna say it. I'm not saying that she knows or that she knew that was wrong, because to her and to Mark Garcia, I believe Mark Garcia believed he was right. He went in there and talked to a judge about it, and then the judge said, well, what about this and this and this, and he added those things. I believe that Mark Garcia was terribly wrong. I believe that the whole thing was a farce. It could have been stopped at the magistrate's office, and it wasn't. However, those text messages show that Michelle went back to the DAs and said, look, what's the problem here? What is the issue? And that should tell the court that she truly did believe in Mark Garcia. Whether or not it was the correct thing, I'm not saying that it was correct.
Even after Mr. James told her, give it to the DA, file it at large, we're going to get in trouble.
Mark Garcia made a decision. Mark Garcia made a decision not to.
And you're saying your client could not have distanced herself immediately from that decision, call it what it was, and say, I have no part of it?
She absolutely could, but
she didn't.
Because she believed in his investigation.
But she didn't, right?
She did not, but she believed in his investigation. But it's not, it's not perjury. I mean, that's ultimately the issue. The DA's dismissed the case because it's not perjury. I'm not saying Michelle didn't make mistakes. We've never argued. We've never argued that Michelle's just been perfect. But I do believe that the pitchforks have come out, and they came out for her because they don't like her. The commissioner's court, the DAs, the public, when they see her, when they play this press conference, and when they play this thing, the pitchforks are out because they feel like she needed to be knocked down. She has been. She has been humbled. She has been humiliated. She has now been convicted. But ultimately, no one is saying that the arrest of Moreno was a correct thing. Nobody is saying that. But there's a difference between maliciously trying to do this and mistakenly believing that, well, he's obviously not telling the truth. Because he didn't tell the truth. I mean, I think that even with the evidence that they've shown, that he didn't tell the truth about things. Now, you and I and everybody else who's in our system understands that that's not perjury. The magistrate judge should have understood that. Should have, but didn't. The reason we have the magistrate judge is because police officers often make incorrect decisions about what a crime has been committed. They do. We don't go and get them off for perjury. Even when they believe that incorrectly that a crime's been committed, we don't go, you're indicted now for perjury. We should have a magistrate there. That's why they're there to say, we should have a DA's office there, right? And we do. But when it doesn't go to the DA's and it goes to the magistrate, that's the stop. And that part of the system failed. Because there will always be police officers who mistakenly believe that a crime has been committed. There will always be police officers. I worked as a magistrate prosecutor for 5 years. I told police officers every night, that's not it. You don't have it. That's ridiculous. I had a lot of pushback from them. I got them coming back with new reports. I got them doing all of those things that she did. I got them doing it, and I didn't for once assume that these people were malicious people. These officers were malicious. I knew that they were a mistake. And they don't. They knew more than I did. Now, yes, it's bad. It's wrong. It's not prison law. She's been convicted. She's going to be under the jurisdiction of this court. But the reason that they couldn't get perjury is because they couldn't prove perjury. And they didn't in the punishment. Additionally. And I have spent a little bit of time. I'm in 4 minutes. I'll probably talk about Saturday. The official oppression and the unlawful arrest of Leo Moreno, we talked about that. Subjecting Leo Moreno and Christopher Nicholas to mistreatment. The evidence that you heard was not evidence that would rise to that level of official oppression in these counts. That was part of the problem of why it was so damaging during her trial in front of the jury, that they would still continue to try to bring that out after you heard what they were talking about. They were talking about being assigned bailiff and having to wear a shirt that said bailiff and security on it. That was their mistreatment. And nobody's saying that there wasn't dysfunction in that office. She had to hire back people that she had fired for provably lying. Still on their people. They lied about their training. And she had to hire them back. And that's going to cause dysfunction. That's a part of our system. I think it's a problem. Because if you fire somebody, and it's not she didn't fire them wrongly. I mean, they got put back on, but it's T-Call that did their investigation, and that was shown and proved to the court. T-Call did their investigation showing that they had lied. Everybody agrees to that. The false information to the ranger about the condition of her vehicle. The reason we introduced the thing is because it's just a confusion of words. She said the tire slashed. They said the tire's flat. But we introduced the recording to the court that showed that when they went and looked at the tire, they said they could see, oh yeah, there is like a slash there. It was not flat, but it was slashed. Now, it's a small thing, but it's only if you check everything in the light most damaging to her, which they have been more than willing to do throughout the trial, that the public has been more than willing to do, the media, everyone else has been more than willing to do. But when you look at it, we have presented evidence that there was a ranger looking at the tire and noticed the defect. And that's important because that's what she's talking about. So there's a defect on the tire. She never said, and they didn't present anything where she said, my tires were flat. The tire was flat. The cease providing security. She wasn't intending to stop providing security. The reason I had Judge Vasquez was to say that there was some exchanges where she was saying, I am the person that should be doing it. And she was being prevented from doing it. And they went and sought a contract with a private security person and told her that private security was going to be doing private security. After thing. Throughout the entire time, though, she consistently said, I am supposed to be the person doing it. Judge Vasquez didn't want her to do it. And that's a difference. There's a difference. If you don't want her to do it, that's one thing. But she wasn't trying to be derelict in her job. She was trying to do what she thought was her job, and she was being told that, no, I don't like the way you do it, and so we're going to have private should she be in pissing contests with Judge Boscovitz? I mean, no. Could she have backed down? Yes. Could there have been a better way to work? Yeah. Even the way he testified, I don't know that. I think that there was blame on both sides there. We showed you the video of him screaming at her people. There was obviously some unprofessional conduct going on both sides of this equation. Now, the warrants and releasing defendants with active warrant. There's a part of the law that says you can do it in these situations, but you can't do it in these situations. Again, nobody is, I'm not saying that she is a legal scholar. It happened for a few months and then it stopped. And that was it. She went and talked to the DA, they went and had all this stuff, and then it stopped. Because that is more process issues. Like, so yeah, okay, you can do it here, but you can't do it here. The code is confusing. It took me a long time to read it just to understand when and where you can do it. And that will happen. I mean, that's going to happen throughout our county. Constables and other law enforcement agencies are going to make wrong decisions about how to arrest, when to arrest, what to do, and blah, blah, blah. They get counsel on it, and then they change the view. The left the precinct 2 facility, that's fine. I mean, we heard the evidence from Constable Boston that the credit cards were frozen by the commissioner's court after the commissioner's court wanted her gone. She was doing the best that she could, and it was frozen. She wasn't intending to leave the finances in such a way. She had no control over whether those credit cards were frozen. The commissioner's court did it at the time that they were trying to get her removed from office. And that's when the new constable came in. And so yes, there were some issues that can't reasonably be used as punishment. And finally, operated a car company without a license. I want to go back to the trial. Throughout the entire time, the prosecution's table asked you to let them talk about the fact that that was her motive. That was the motive that they tried to bring up. Please let us talk about it. And then they finally put a witness on there, and the guy said, I don't even know if it's a crime or not. I couldn't even tell you if she was to. Now, that leaves you two things. One, they already talked to him, and they knew that when they talked to you. Or they didn't talk to him, or they didn't understand, or they wished it to be true. Because they're still looking for the motive for why this would happen. She's trying to conceal the fact she's operating a car company without a license. But their own witness said, hey, I don't even know that that's true. I'm not saying that they knew that wasn't true. It was trying throughout the entire trial to get you to let them talk about it, knowing that it wasn't true. But it really brings the point up that they wanted it to be. Because they wanted to find anything that they could find to explain what was doing. They tried to do it, and it failed. I mean, it failed miserably. And that's a part of how we look at all the actions during the trial. And I want to remind the court, too, that the court had the best, for the crime itself, for the conviction itself, the court had the best evidence that the court could have of what her mentality was as far as trying to hide things, as far as trying to intimidate Susan Tristan. And that was when they put a fire on Susan Tristan for 3 days. And they found not only did they not find anything incriminating, but when Susan Tristan was supposed to go over, and Michelle knew that she was talking to an investigator who had sent a subpoena, who were asking for the documents, that Michelle, if you believe Susan Tristan, Michelle knew that Susan Tristan knew everything if she was trying to do something wrong. Susan knew about this, Susan knew about these, and Michelle, sitting in a room with the others, when they said, go tell the truth, she agreed. And then she came out and told Susan, and it's on the recording, you're going to be okay. It's okay. It's going to be. That shows you, when you're trying to determine the proper punishment in her heart, that shows you that her heart was not in this place of like, of I want to conceal and hide and do whatever. Or on the wire, that she did not know was being recorded. She would have told Susan not to be on top of about it. It was stuff that we did. She didn't. And ultimately, when you're deciding her punishment, and you're deciding who she is, she had every opportunity to be a bully in that situation. She had every opportunity to cause Susan harm or to threaten her to do whatever she did. She agreed with the statement of telling the truth, and she said, it's okay, I'm just going to fine. That's it. Finally, the Dr. General. Now, that is obviously, and Mr. James said, it's not right. You know, and she would agree with that. I mean, and we all do. Sometimes, in situations, a parent does things that are not appropriate in that situation. Now, I'm not saying that every parent would do this, but I'm saying that it is understandable for a parent who believes that their child has been wrongfully accused to be upset about it. Now, that was the wrong way to do it, but Mr. James agreed with that. And that's important for the court to understand, is because he was not, Mr. James is not a chauffeur. He loves her. He's not a chauffeur. And he agreed with that. And he was honest about his opinion, about his thoughts about that. And now you connect that to what Mr. James said about going in to Mark Garcia and going in and talking to him and saying, look, this is the thing. And I asked him, did it feel to you like Mark Garcia was going to do whatever he wanted to do? And he said, yes. Yes. He wasn't going to listen to anybody. And he goes back to your concern. I understand there are concerns about that. Of course there are. She was wrong. She was mistaken. She was not malicious in that sense. She believed Mark Garcia. She was wrong about it, obviously. They're going to play you. They're going to play you and show you again, look how much hubris she has. And I will just say to the court, the proper statement is, look how much she has. She's been humbled. She's been humiliated. She has been. She's been pilloried. She's been put in chains. She's been marched down the hall in front of these men. All of these things have happened to her. And now she is in a situation, for the final thing that I want you to consider, now she is in a situation where she has picked up her life. She has a business. She employs people that were homeless. She raises her children. She homeschools a child. And I'll just tell you this. I was not going to bring an 8-year-old to single mom homeschool. I know that they tried to cast doubt on that. Her employee did not understand this, her child's education situation. He understands what he does. I wasn't going to bring an 8-year-old to do it because this has gone on long enough. And I'm not going to bring that child into here. But I'm telling you, she homeschools her child. She is responsible for her child's education. She has a young child who is 8 years old. She has been humiliated. She has been humbled. The purpose of this system is to say, who are you now? Not who were you then. And who are you now is somebody who will follow your orders, as she has. Anytime you have given her one, she will follow it. She will do well on probation. You can see from her PSI that she has no issues with probation or anything else. She is not in a position of authority. She has been kicked out of her office for her hubris. She's been kicked out of her office because they wanted her gone, and she's gone. She has now been convicted. And we're asking that you allow her to continue with the life that she's built now, outside of the media's eye, outside of all this other things. Allow her to be back with her family. Allow her to continue to do the good that she is doing now. Law enforcement, constable, that was not the position for her. It's obvious. That does not mean that she should go to prison for this. So we are asking for to please allow her on probation, to grant her probation, or to grant her the ability to continue to be a mother, to be a boss, to be a friend, to be a sister-in-law that she has been. Because there is another side to her that no one has been willing to see. But we have presented part of that side, and we ask you to consider that when considering what the appropriate says.
Telling us, I think this goes all the way to 44 minutes, so if we want 44 minutes.
Make sure my technology works. We have the board of opposing counsel. So yes, conveniently she backed her captain in the arrest of Leo Moreno. Why? Because Leo Moreno was her political opponent, one. Second, Leo Moreno also filed complaints against her. And so of course she was going to back him. Why? Because she wanted him arrested. And the court pointed out correctly that even after the case is dismissed in May, she's still advocating for an arrest of Leo Moreno. And later in the presentation, we'll also see that subsequent to that, even in September, while FBI and the Texas Rangers are raiding the constable precinct's office, she's still advocating that Leo Moreno should be arrested. And this is after she knows all the facts and circumstances surrounding the arrest. She's also the complainant in that arrest. I have the words public corruption and Michelle Vela up there. This was a public corruption trial. We presented evidence of public corruption. We presented evidence of public corruption within the punishment phase. Those words are now synonymous. What was she convicted of? She was convicted of 2 felonies. The evidence in those cases proved that she used her powers as an elected official, she violated the trust given to her as an elected official, and her actions throughout the trial, we can kind of get a glimpse into her state of mind. Her reactions to when the grand jury summons are issued are what? Designate others as custodians, not submit a business record affidavit when the grand jury summons is specifically addressed to her. She goes about writing up employees, she's telling Susan she needs a lawyer. Again, all done in order to shield herself or kind of take a step back from any sort of accountability. And the argument of, well, she made 7 copies and all that, and how would, but again, the only person that knows what was actually turned over is her. So when she takes 1 copy, she takes out the documents that she knows are incriminating her or bad for her and she doesn't want turned over. The only person who knows that she took them out is her. So she's not going to go around taking out all the documents. So we knew a lot of things, or at least we found out about a lot of things within the trial, but essentially we don't know where's the money. So we found out that the office actually took cash payments for Rodriguez Park Security. We know that the defendant was the person who received that cash. We know that reserve deputies worked at Park and were not paid. So
Can I stop you right there?
Yes.
Yesterday when the auditor was here, I asked him if that practice is still going on, and he said yes, but they have not changed that.
Actually, I've been informed that after this case came to light, all of the security is now through the county parks now. There's no longer any of this walking into the precincts and paying money for security. Everything runs through the county. The HR people put into place the contracts like when they did it for that one day on the sending to the general security. They've now put in those contracts in place so they don't have to worry about violating the Security Guard Act. And so that all has been revamped and cash is not taken in that manner anymore. It flows through the county auditor system, and that's how everyone's being paid now.
That's just testimony for her.
Well, I specifically asked if there's any other county office that allowed county employees to take in cash from the public, and then same employees give out cash to other employees. And I believe he answered the affirmative. So, well, that was my only concern.
Well, during the trial, we wanted to elicit that testimony from parks people about how things have changed and how it is today, but we weren't permitted to get into that because it wasn't relevant to what happened in the county office.
Okay, go ahead.
So the defendant knew what she was doing. Again, it's her objective to have that concealed.
But there was evidence that this practice was going on even before her, with and in other constable offices.
That's correct. Yes. Oh, and my little graphic is not showing this. That's weird. So the defendant is dishonest, and I'll point to the defense exhibit 10, which was. Why my graphic didn't show. Oh. So, defense exhibit 10 was after Easter.
Yes, I remember.
Recall defense exhibit 10. Okay, so that shows the defendant's dishonesty and her lying about simple things. Again, that's a government record that in that document is not true. And how do you know it's not true? Because the defendant's own statement subsequent to that, in her interview with Matthew Steele, says that Mrs. Gray had actually paid $150 each her and her chief deputy, Castillo. But again, we also elicit testimony that she wasn't even the person that worked with the victim, it was the other deputy. So again, all these contradictory statements which go to show she's a dishonest person. She's not truthful. And again, going back to Matthew Steele's interview.
Are you saying she's the only dishonest person in that precinct? She's
No.
the only one that had, I mean, are you saying anybody else in that precinct had clean hands coming into this prosecution? What about the evidence of people submitting TCO reports that were not truthful? There was witness.
You're talking about Bexar and Moreno. We didn't bring them to testify because we know that they were investigated for sexual incidents and that there was a finding that they were dishonest. So we did not bring them.
Somebody else testified to that.
Well, a lot of people.
Minor, I believe.
Well, on cross-examination, yes, we did testify to that.
So I guess to answer your first question, yes, there are other people who are dishonest in the same precinct, yes. There is one person who was in front of this court who was convicted of 2,000. The defendant's primary concern was not security. The defendant admits in a Matthew Stewart interview that the Reyes party suggested that a relative who worked for PCSO come out and provide security. But the defendant's response was no. So again, picture this in your mind, right? It's really a unique set of circumstances that can only be accomplished by her. And I think that's what's kind of important in this case is that the facts and circumstances are so unique that it takes someone in her position of power, to have been able to accomplish it. So in this fact scenario, someone shows up and trying to have a party, they say, oh, well, we can provide security to your relatives. So no, you have to pay me. Again, that would, to an average person, that is absurd. It is crazy. The defendant lied about her tires at the certain point. Again, this goes back to her intent to impede any investigation, to not be cooperative. The Family Dollar intimidation. Her son is accused of a prior shoplifting incident and is told he can't enter the store. So at some point, the defendant decides, I'm going to misuse government resources to settle a personal matter. Again, a fact scenario that is so unique, that is so outside the realm of what a normal person could do. I couldn't do that. It would be like, I guess it would be like the elected district attorney going and summoning every single investigator or a team of investigators to go out to a personal matter. We would think that was crazy. And that's what she did. She wasn't in danger, and the manager was well within her right to exclude the defendant's son from the store. And instead she said, okay, I'm going to take everybody off traffic so they can come over and just stand in the store while I have a disagreement, I have an argument with the manager. Again, that goes for abuse of power, for abuse of resources, for public corruption. The execution of warrants. So even after she was instructed to cease and desist, she continued to do so. And there was a statement that she made that she knew the code of criminal procedure better than any lawyer, better than any judge. And we have proof of 93 improperly executed habeas corpus warrants. So we go back to the arrest of Leo Moreno. Files a EPOC complaint against the defendant. Against the defendant. Leo Barrientes was then subsequently arrested for perjury based on statements he made in that complaint. Again, it goes back to, it is a unique set of circumstances that allow her to do this. Very few people could actually get someone arrested. I think about it in my own job, right? For me to get someone arrested, I would have to file a case at large, I would have to go and get them indicted, but there's checks and balances along the way. And again, she was able to arrest someone, have someone arrested, that was a person who complained against her and her political opponent. And even after that case is dismissed, she still wants Leo Moreno arrested. And the basis of that arrest is for lying in a complaint that was made against her. And so how do we know she still wants arrested? The court pointed it out. And of course, my graphics aren't showing. Are the text messages that we presented before. Well, I dropped off the prosecution package. And, oh, we dropped off the prosecution package with additional evidence. And there's one text message that states, all elements were presented before and again today. So again, it goes into her mind that she believed you should have been arrested back when, in April 30th, that she's again present for the briefing. And then it's still saying, well, you have to be arrested today. And she knows the reason for that arrest is the statements that he made against me in that EEOC. And then so we go to, while the Rangers, and I'm going to approach this for you. While the Rangers and the FBI are executing a search warrant at her employment, at her office, she makes this statement. I'm going to turn upside. I don't know how I do it. So apologies.
Leoncio Moreno, he was arrested, and then the charges were subsequently dropped. Any thoughts on that? I tried calling your personal cell phone. Did they confiscate your personal items?
Again, this is her advocating that her political opponent, that a person who filed an EEOC complaint, be arrested, and this is months after it's been dismissed by the district attorney's office, and months after they dropped off a subsequent file being filed at large, she'd still say he should be arrested. And that warrant was given. And again, this is all going on while her office is being searched by federal authorities, Texas Rangers, as a result of a search warrant. And we can also see a double standard that she plays, which is, I think it's 1122 right now.
Yes. Said I forgot to. Well, thanks so much.
So as a law enforcement officer, she would know that this isn't done for some big show. She would know that federal authorities are there, Texas Rangers are there, they're executing a search warrant because the court has signed off on it based on probable cause. And also, you see the deflection that she does, in that she makes an accusation against the son of Judge Wolf, Kevin Wolf, about pedophilia or something like that. Again, all goes to the type of person that she is. That when the walls are closing in, let me blame someone else. Let me go in here and put blame on someone else. She can't ever be accountable for what she did. I mentioned this before and a few times, and then go back to the future. The case is a very unique set of circumstances. And that's what makes it unique. Only someone in her position of authority, in her position of trust, could have accomplished this. The state is asking that you sentence her prison for 6 years. And I know sentencing someone to prison, asking that someone be sent to prison, is a difficult thing to do. I know that sentencing someone to prison is difficult. But it is the right thing to do for this case in a unique set of circumstances that she herself covered. Herself. She abused the trust of the people. She abused her office. And it is such a unique set of circumstances that only she could accomplish, only someone in the streets of power could have done. And she did it. We asked this court to send that message that this is not okay. What she did was not okay. Her behavior, not only for what she was convicted of, but her behavior within the office, misusing government resources, is not okay. And we asked the court that she be sent to prison. Thank you.
Okay, so as I explained yesterday, I'm going to recess for lunch, and everybody meet me back here at 1:30 for the announcement of sessions. I am going to lock the courtroom because I do have to view some of the evidence, and I can only use this equipment. So if you have somebody here and you need to carry a lunch break, take it with you, because I'm locking the doors and I'm not going to open the lock until 1:30. So we are in recess until 1:30.
Come gave his. He should be under investigation now.